Mr. Marshall, the Supreme Court has reconvened. The next case on the call of the docket is agenda number 3, case number 124807, People of the State of Illinois versus Ronald Lee Stoecker as the appellant. Mr. Boyd, you may begin.
Good morning, Your Honors. Andy Boyd from the State Appellate Defender's Office on behalf of petitioner Appellant Ronald Stoecker, if it please the court and opposing counsel. The central issue this case presents is whether the manner in which the courts and the attorneys proceed, in other words, the fundamental notion of due process of law, whether that matters every bit as much as the result of any given proceeding. And it's my position, and it ought to be the position of this court, that the answer to this question is a resounding yes. And there's two related reasons why I take that position. The first is that the fundamental integrity of the way circuit courts and all courts proceed is something that we value in and of itself, regardless of the outcome of the proceedings. In other words, we don't take shortcuts on our way to justice in the state of Illinois. And the second reason, as a practical matter, this court's decision in this case is going to affect Section 214.01 petitioners moving forward. Now, some of these petitioners are going to have meritorious claims, and these petitioners are going to be hurt if their petitions are treated as shabbily by the circuit court as the way Ronald's petition was treated. Now, the central issue that I've raised can be broken down into two separate but related issues. The first is that of a litigant before an Illinois court who was given no reasonable chance to respond to a motion to dismiss the Section 214.01 petition, and whose petition was then dismissed during an ex parte hearing. And this first issue is whether this comports with due process, and the answer is no, it does not. The second of these issues concerns appointed counsel's abandonment of Ronald. And again, this does not comport with due process, nor does it comport with the basic rules of competent representation for attorneys in the state of Illinois. Now, before I get into the nuts and bolts, so to speak, of both of my arguments, I'd like to briefly address Ronald's status as what might be called a frequent filer. I would acknowledge that Ronald was convicted of a terrible crime in this case. I would also acknowledge that he's filed a number of previous unsuccessful petitions since he was convicted. So one of the questions this court might be asking is, well, how should the court system treat such a petitioner? Judging from the state's brief, the answer to this question might be, well, what we can do is we can take shortcuts in the circuit court, and then on review, we can simply whitewash this whole thing with the harmless error brush, and then we can simply be done with it. That's the wrong answer, Your Honors. It's my position here, and it should be the position of this court, that every litigant that comes before the Illinois court system is entitled to the same level of due process. It simply cannot be the case that we have a two-tiered system of criminal justice in the state of Illinois in which courts are permitted to afford some litigants a higher level of due process and some litigants a lower level of due process. So this is one of my central arguments here in this case. Every litigant that comes before the Illinois criminal justice system is entitled to the same level of due process. And at the risk of being overly dramatic, let's take a second and let's recall the iconic image of Lady Justice blindfolded holding a scale. It's a powerful image, at least it is to me, and its meaning, as I understand it, is that regardless of who a litigant is, justice is going to be applied for that litigant fairly and equally without regard to that litigant's economic status, without regard to that litigant's social status, without regard to any other status this particular litigant might have. And if we don't do this, Your Honors, I respectfully submit, if we don't treat every litigant equally in the Illinois criminal justice system, it diminishes all of us. It diminishes the defense bar, it diminishes the prosecution, and it diminishes the courts, and we simply shouldn't act this way. Now, with those preliminary remarks out of the way, I'd like to talk a little more specifically about the two issues that I raised in this case. And the first is that Ronald's due process rights were violated in a prejudicial manner, where the circuit court granted the state's motion to dismiss his petition for relief from judgment without giving him a meaningful opportunity to respond, and where the court dismissed that position during an ex parte hearing with only the state present. We know from this court's decision in Vincent all the way back in 2007, in section 21401 petitions, challenging criminal convictions are governed by the ordinary rules of civil procedure. And that means that section 21401 petitions are essentially complaints which invite responsive pleadings, which means that the state can file an answer, the state can move to dismiss, or the state can simply ignore the petition. Now, it is true that when the state ignores a 21401 petition, what happens is it admits all the well-pleaded facts, and the petition then does become ripe for a sua sponte dismissal. We know this from this court's decision in Vincent. But that's not what happened here. The state chose to file a motion to dismiss. It raised issues of timeliness, res judicata, and the lack of supporting documentation. When the state chose that route, when the state chose to file a motion to dismiss, Ronald then became entitled to respond to that motion to dismiss. It's well established that due process doesn't allow a trial court to grant a motion to dismiss a complaint without allowing the opposing party notice and a meaningful opportunity to be heard. We know this from the Bradley case, 2017, 4th District. Also from Justice Kilbride's dissent in the Vincent case way back in 2007, where Justice Kilbride quite properly observed that if the state had filed a motion to dismiss in that case, the defendant would have had an opportunity to file a response. And so where we're at here, at least as far as this first issue goes, Your Honor, is that the right to be heard is a bedrock principle of due process.
Counsel, could you help me understand the record? What was the basis of the motion to dismiss? Actually, I have two quick questions. What was the
Sure,
basis
Your
of the
Honor.
motion to dismiss?
As I recall, and I can go ahead and take a quick peek at my brief here to answer Your Honor's question as best as I can, because the record was a paper one, and I unfortunately don't have it before me. But from what I'm recalling and what I'm seeing in my brief is that the state argued issues of untimeliness, that the issues Ronald raised had previously been litigated, and I also seem to recall that the state argued that there wasn't any supporting documentation. Those are the things that the state had argued, Your Honor.
Is it a res judicata argument?
That's my recollection. Yes, Your Honor.
Thank you.
So where we're at here is we have Ronald, who has filed this petition. He's been appointed counsel. Counsel has not at this point filed anything. No motion to withdraw, no amended petition, no nothing. 2 months later, the state files this motion to dismiss.
That's my other
What
record question. Can I ask you this? How did the lawyer get appointed in this 21401? Was it a public defender? What happened? Do we know?
Sure. As best I can tell, this was in Stark County, which is a relatively small rural county. In my understanding, and I'm going a little bit off the record here, but I'm just trying to answer Your Honor's question. My understanding is that in some of these smaller counties, the public defender may not actually have a quote unquote office, so to speak, like they would in a place like the city of Chicago, where there's a number of attorneys working. There may just be one public defender, and some of these cases are then farmed out, so to speak, to local counsel who may be appointed to the case by the court. And it's my belief that that's what happened in this case, that the circuit court looked at this petition, decided for whatever reason that the petition was serious enough to warrant the appointment of counsel, and counsel was appointed in the manner of a public defender. At least that's my understanding, Your Honor.
So you can see that certain procedural errors in 21401 proceedings are subject to harmless error review. You can see that at page 13 of your brief. And then you cite Rucker and Bradley for the proposition that here harmless error doesn't apply. I would note that in Rucker, harmless error was never raised. The state simply indicated that there was no due process violation. And in Bradley, as we know, since Bradley, the 4th District has come down opposite Bradley on a couple cases. So, I mean, why wouldn't harmless error apply here as it has in the subsequent 4th District cases?
The answer to your question is, Your Honor, and this goes back to the integrity of the proceedings. How much integrity would this honorable court like for there to be in circuit court proceedings. What happened here was frankly procedural slop. The court, so to speak, didn't cross its T's and dot its I's. And I understand that there is some case law going the other way, but the bottom line, at least for me in this case, is that what's at stake here in any criminal proceeding, and a 214-01 proceeding has been extended to criminal proceedings, so this one was criminal. Somebody's freedom is at stake here. And what's important is the essential integrity of the proceedings. And there was no such essential integrity of the proceedings in this case. And so when we talk about prejudice, yes, we would have to concede in this particular case, in Mr. Stoecker's case, there probably wasn't much that could have been done to amend this petition so that it would be meritorious. Probably wasn't a whole lot that could have been done along those lines. But the problem is, if we start whitewashing these things under the rubric of harmless error, some litigant is going to be harmed. There is going to be a time when there's one of these rare cases where one of these pro se section 214-01 petitioners raises an issue that's meritorious. And if this gets swept under the rug, so to speak, by the circuit court or missed somehow because of sloppy procedures by the circuit court, then that meritorious litigant is placed in a position where it's going to be a very long time before any ultimate relief is granted. And part of that is due to the practical problem that OSAD has. Most of these cases go to OSAD. We have many more cases than we can handle. As a result, it's between 12 and 18 months before we even get to a case. The appellate prosecutor is also overburdened. It's maybe 6 to 8 months before they get to a case. The appellate courts are overburdened. Sometimes it's up to a year before we reach a decision. So we could have a situation where there's a litigant who has a meritorious claim who waits for up to 3 years for the relief that he or she should have obtained in the first instance in the circuit court. So to answer Your Honor's question, yes, I acknowledge the case law talking about harmless error. I simply disagree with that. I think there's two arguments to be made against it. And the first is that the essential integrity of the proceedings matters. It matters in and of itself, and it matters a lot because that's what we do here in Illinois. We do things properly. We dot our T's and we cross our I's. And it also matters for the practical reason that I've described. If things are done sloppily, somebody's going to be harmed.
You concede, counsel, that if there had not been appointed counsel and nothing filed, that there would not have been anything under Vincent. The court could have proceeded to look at the petition and decide whether there was anything there.
Yes, Your Honor. Clearly, under Vincent, if the state had chosen the option of doing nothing, the circuit court could have simply dismissed this thing sua sponte, but that's not what happened here. That's not the case that we have. The state, for whatever reason, we don't know what these reasons are, the state chose to go ahead and file that motion to dismiss. And when the state did that, it changed the nature of this case. If I could, I'd like to talk, before I run out of time, I'd like to talk some about the second issue that I've presented here, which is appointed counsel's failure to do anything on behalf of Ronald. And I have to say this, frankly, I'm amazed that I'm required to present any sort of argument on this point at all. Dissenting Justice Litton in the 3rd District's decision here correctly observed that the record does not show that appointed counsel provided any actual representation to defendant. How in the world can it be possible? Can it be acceptable for a court-appointed attorney, or any attorney for that matter, to do absolutely nothing as his or her client's case swirls down the drain? The answer is that it is not. It cannot possibly be acceptable. Now, one of the issues that we raised was this difference between what sort of standard a appointed attorney might be held to in section 214-01 petitions. The first thing I point out is, just as I pointed this out in both of my briefs, this court could decide this case without delving into the issue of whether due diligence or reasonable assistance is the better standard. And one of the things I've also pointed out is when you really take a close look at these two standards, they don't look very different. But I would stand on the arguments that I made in my brief and say that if this court decided that it did need to reach some decision on which was the better standard, the reasonable assistance would be the better standard, simply because it's closer to what's required of a post-conviction attorney.
May I ask you this? How do you get a lawyer? There's not a statutory requirement for the appointment of counsel, correct?
Right. To answer your question, this was a discretionary appointment. The state correctly points out that there isn't any constitutional right here for appointed counsel, nor is there any statutory right to appointed counsel. We agree with that. But the circuit court, for whatever reason, and we don't know the precise reason the circuit court decided to appoint counsel for Ronald, but that's what the circuit court did. And it's similar to the Tedder case that I cited in my opening brief. That was a civil matter. The circuit court didn't have to appoint counsel for the petitioner there, but the circuit court did so. And once the circuit court did so, a minimum obligation of competent representation kicked in at that point. Now, whether we didn't want to describe that, whether we want to phrase that as reasonable assistance or due diligence, well, frankly, that doesn't matter very much. My argument would be that, well, if we're going to decide reasonable assistance would be the better one, but due diligence is very similar and would be okay. But to answer your Honor's question, what happened here, this was a discretionary appointment, a simply discretionary appointment by the circuit court. And once the circuit court made that decision to appoint counsel, that's when these obligations kicked in.
Counselor, you indicated earlier that prejudice might be a little bit of a hard hill to climb in this case. Justice Litton's dissent talked about the discussion of prejudice has no bearing on the adequacy of counsel here. My question for you is this. If a defendant who has the constitutional right to counsel has to climb the hill of prejudice, why would this defendant, who has neither a constitutional right nor a statutory right to counsel, be absolved of that burden?
Sure, that's a fair question, and I can. What I can do to answer that question is point to a couple of different places in which there isn't any need to show prejudice in order to get a remand, in order to get a new attorney, in order for a petitioner to move forward with his or her case. And the first is in a Rule 651C remand in post-conviction petitions. It's well established that there's no need to show prejudice when there's been a violation of Rule 651C, because we don't know what the record would have looked like if counsel did his or her job. That, I think, is the reasoning behind these automatic Rule 651C remands. We don't know what the record would be like. So what we have to do is send this thing back automatically so that we can fill out the record and figure out exactly what should have happened in the first instance in the circuit court. And the second thing I would direct your Honor's attention to is this court's decision in 1992 in Tedder, which I briefly talked about previously. This was a civil case. Counsel was appointed. Pro se prisoners were alleging a lack of medical attention. And this court held that where counsel's appointed, counsel is required to meet a minimum level of representation. When counsel doesn't do that, there's no meaningful access to the courts. Prejudice wasn't discussed in the Tedder case. Prejudice isn't discussed in Rule 651C remand. So the way I would answer your Honor's question is that there is some authority that in some instances there doesn't need to be a showing of prejudice. And I argue that this is another one of those instances. We don't know what this record would have looked like had counsel gone ahead and done his job. That's why we need this automatic remand in order to flesh out the record, Your Honor. That's the best I can do in answering Your Honor's question. Let me just point out briefly before I close here, and this is only, by the way, a suggestion. This court is clearly free to accept or reject as it finds fit. But I would point out that if this court issues some sort of either a common law rule or even goes so far as to promulgate a new Supreme Court rule requiring that appointed counsel in these 214-01 petitions does one of three things. Either file and proceed on a amended petition, file a
Mr.
motion
Boyd,
to withdraw. Yes,
your time is up. You can finish your sentence.
okay. Or file a motion to withdraw. If council does one of those three things, if there's a rule requiring council to do one of those three things, we don't have the procedural mess that we have in this case. Thank you, Your Honors.
Thank you, Mr. Boyd. Mr. Ellsner?
Thank you, Your Honor, and may it please the court. Counsel, I'm Assistant Attorney General Evan Ellsner on behalf of Appellee, the people of the state of Illinois. Petitioner has conceded already that the 214-01 petition here had no merit. He says now that he probably couldn't amend the petition, but he stated in his reply brief that he makes no argument that the petition states a valid claim for relief. So he's already waived that argument, or at the very least forfeited it. And so there's also no dispute that he's suffered no actual harm or prejudice from the purported errors below. Now, in spite of this concession, petitioner has asked this court to reverse this case as a pure formality and to remand an irreparable petition, his third 214-01 petition, and at last count, his 8th overall attempt at state or federal collateral relief, to remand this irreparable petition to the trial court, knowing that it has absolutely no chance at survival there. And not just that, he's asked this court to establish an automatic reversal rule, an exceedingly rare remedy for all 214-01 cases, no matter how futile the claims that are alleged, or how many insurmountable procedural bars the petition faces. Now, setting aside that petitioner has identified no legal bases for the due process right that he claims the trial court violated, or the standard of representation that he claims his discretionarily appointed counsel violated, he certainly has not shown how either violation is so grave and incapable of qualitative assessment that it requires the extraordinary remedy of automatic reversal. It's important to remember that there's a very strong presumption against automatic reversal rules, and that presumption petitioner has not overcome in this case. The state acknowledges that this case may not have proceeded in an ideal fashion, but not all deviations from best practices constitute error, and an exceedingly rare few errors require automatic reversal. And the petitioner's petition countervails the very notion and existence of harmless error review for most trial court errors and prejudice analysis for most claims of inadequate performance by counsel. The court routinely endorses consideration of the merits or lack thereof of a case on appeal, despite the occurrence of an error below, in the interest of judicial economy and finality. And similarly, the effective assistance standard, a higher standard of representation than any that would be applicable here, explicitly includes a prejudice prong and reasons that even professionally unreasonable errors by counsel do not warrant setting aside the judgment if they had no effect on the judgment. So ultimately, this court need not break new ground on a due process right to respond to a motion to dismiss or a standard of care applicable to discretionarily appointed 214-01 counsel, because whatever the outcome on those issues, the alleged errors here are amenable to review for harmlessness or prejudice, respectively. And it's clear that petitioner was not in fact harmed or prejudiced, where his 214-01 petition suffered from multiple incurable defects on matters of law. So if I could turn first to the alleged due process violation, petitioner has presumed that there's a right to file a response to an opponent's motion to dismiss at all. And then second, the violation of such a right is of an error of constitutional magnitude, not just an error. But while it may be typical practice of trial courts to permit responsive briefing, there's no statute or rule that requires it or otherwise precludes courts from ruling on a motion to dismiss alone, particularly here where there's a motion to dismiss raising an incurable objective matter of law. But setting aside that petitioner hasn't identified any existing right to a responsive filing, he certainly hasn't explained how the violation of such right amounts to a violation of due process, or how this court's reasoning in the Vincent case fails to apply here to what the Smith court aptly described was a mere factual variant of the same question. And it's critical to note that, as petitioner has acknowledged today, in the Vincent case, what rendered the 214-01 petition ripe for adjudication on a matter of law was the state's failure to respond, but because that failure to respond constituted an admission of well-pleaded facts. And motions to dismiss under the familiar controlling legal standards for sections 2615 and 2619 also take all well-pleaded facts as true. So adhering to the Vincent school of thought, this should mean that a motion to dismiss similarly renders a 214-01 petition ripe for adjudication. And in fact, this court in Vincent cited to the Marshall appellate decision for the proposition that a judgment on pleadings in favor of a 214-01 defendant who has not responded is, quote, the functional equivalent of a dismissal for a failure to state a claim. And that's a dismissal under section 2615. So this alone establishes that the petition was ripe for adjudication upon the opponent's filing of the motion to dismiss. And as this court alluded to in its questions, the res judicata issue that the court ruled on, it could have granted that dismissal sua sponte if the state hadn't responded at all. Turning to whether petitioner's opportunity to be heard has been compromised, it's important to remember that every relevant consideration in Vincent is equally applicable here. In both the cases of sua sponte dismissal and a dismissal on an opposing motion to dismiss alone, petitioner's only opportunity to be heard prior to dismissal is the petition itself. But that petition itself is an opportunity to be heard. And as this court held in Vincent, noted in Vincent, the filing of the petition combined with the consideration of it by a judge provides satisfactory access to the courts. And the ability to bring a meritorious claim certainly isn't violated, where the claim has no merit on a matter of law, and that deficiency cannot be cured. In these cases, as this court noted, the efficient use of judicial resources weighs in favor of permitting the expedient dismissal of a meritless petition. And just as in the case of sua sponte dismissals, where there's a dismissal on a motion to dismiss, multiple procedural safeguards which this court deemed adequate to protect due process in Vincent, remain available as necessary to correct an erroneous termination. And I would just note that these aren't just appellate safeguards, which petitioner notes might take a long time to take advantage of. This court noted that it was adequate, that the additional adequate procedural safeguards included motions to reconsider and requests to amend the petition to yield a meritorious claim. And in this case, the system did work exactly as Vincent envisioned. Petitioner was able to enjoy access to the courts by filing his 214-01 petition and having it be considered by the judge. The court, in turn, was able to save judicial resources through the efficient disposal of what petitioner has, again, conceded he was meritless, or he could not obtain relief. And in addition, petitioner was able to, in turn, avail himself of various procedural safeguards to confirm that the termination of his petition wasn't erroneous. He was able to file a motion to reconsider, and he did, and the court addressed it. It simply denied it, and he was able to seek appellate review. And in fact, if he had any valid basis for reconsideration, the court could have and would have vacated the dismissal and reinstated the 214-01 proceedings. But he simply didn't have any viable grounds for relief or any means for overcoming the various procedural bars to his petition. I would point out that although petitioner has his arguments have generally mirrored the reasoning from Rucker. That reasoning is faulty in several regards. First, as I've already noted, the controlling legal standard on a motion to dismiss is accepts all well-pleaded facts as true. And the Rucker case had argued that there was a distinction between a sua sponte dismissal and a dismissal on a motion to dismiss in this regard, and there simply was no distinction. Second, Rucker incorrectly distinguished the dispositive issue on a motion to reconsider from the dispositive issue on the motion to dismiss. But where the issue is whether an objective matter of law precludes petitioner from relief on the motion to dismiss, that's no different from the dispositive issue on a motion to reconsider, which is whether the court's previous determination was correct that an objective matter of law precludes petitioner from relief under 214.01. And third, I would point out that the Rucker court incorrectly claimed that on a 2619 motion to dismiss, the type of motion to dismiss at issue both here and in that case, petitioner would have had no burden in his response to a motion to dismiss, and is thereby harmed if his first opportunity to address the state's arguments is on a motion to reconsider, where the burden he claims would be shifted to him. But in Illinois, once a 2619 move-ins defense has been established by the motion, the burden is already shifted to petitioner to show in his response how his petition survives the defense. So here, petitioner was in the same position on his motion to reconsider as he would have been in any response to the state's motion to dismiss. If I can turn to the standard of representation argument briefly, I would point out that first of all, petitioner's burden here to establish a record of a violation of a standard of representation, and he hasn't done that. And so the fact that the record doesn't explain what happened here, or doesn't mean that we can simply presume that a violation occurred. At most, he'd be looking at an evidentiary hearing to find out why counsel did or didn't do what he did in this case. But in addition to that, I want to just kind of distill the state's position down to the three fundamental points here. First is that because petitioner under section 214.01 was not entitled to counsel, there's no legal predicate for a standard of representation to apply, much less for a violation of such a standard to require reversal in a civil proceeding that's controlled by the Code of Civil Procedure. Second, even if petitioner was entitled to a standard of care that it attached based exclusively on the trial court's discretionary appointment of counsel, the only standard that could possibly be in consideration for this court is should be the due diligence standard. And finally, whatever standard of representation this court might adopt, automatic reversal would not be appropriate here. At most, a standard prejudice analysis would be proper. I'd like to make clear that even without applying a standard of representation, which is a specific term with specific implications, discretionarily appointed counsel is already held to a baseline expectation of professional responsibility and performance. But this does not mean that the failure to meet those expectations should result in reversal, particularly again in a civil proceeding controlled by the Code of Civil Procedure, which has no particular legislative goal or purpose of providing an avenue of collateral relief to criminal defendant litigants, and which is applicable to civil and criminal litigants alike. And if expectations of professional performance alone were enough to necessitate reversal, then any violation of a rule of professional conduct would be grounds for reversal, but it isn't, not even in criminal proceedings. A standard of representation, by contrast, is not grounded in just the desire to hold an attorney to account for his performance, but it's specifically whether a standard of representation applies and what level of representation applies is proportionate to how and why a right to counsel has been preserved and how to best effectuate the purpose of guaranteeing counsel in that context. And here, 214.01 litigants have no guaranteed right to counsel. The Code of Civil Procedure has no particular legislative purpose to protect criminal defendant litigants. And so that there's no legislative purpose that either needs to be effectuated through a standard of representation, or on the flip side, would be thwarted by the lack of a standard of representation. And it also bears mentioning that this court expressly disapproves of creating 214.01 exceptions that are unique to the status of the petitioner as a criminal defendant litigant. And the requested application of a standard of representation here would require just that. So I want to be clear that the state is not saying that discretionarily appointed counsel would be free to irresponsibly represent his client without consequence, but rather that counsel's duty of care in this context is controlled by the rules of professional conduct. And as petitioner has identified, the reasonable diligence standard under Rule 1.3, along with all of the other rules of professional conduct. But in addition to that, the consequence for such a violation is attorney discipline or liability for malpractice, not reversal of the substantive judgment in a civil action. And in fact, as we've cited to in our briefs, even in the Marrero case, where a due diligence standard of representation was deemed to have applied, the appellate court still found that reversal on appeal would be an inappropriate remedy, was an unavailable remedy because it was a civil action. And I would add that there certainly isn't any parity, as petitioner suggests, between 214.01 petitioners and post-conviction petitioners under their respective statutory frameworks, such that they should be entitled to equivalent levels of representation. At most, we're only talking about potential for a due diligence standard to apply here. But even that standard requires only that counsel perform tasks assigned. And here, no tasks were assigned to counsel, and therefore there cannot have been a violation of the due diligence standard of representation. Now, as this court has noted today, it certainly doesn't make any sense to establish automatic reversal as a remedy for inadequate performance of discretionarily appointed 214.01 counsel, rather than engaging in a prejudice analysis, especially when the standards of representation for both constitutionally appointed and statutorily appointed counsel do include a prejudice analysis before reversal becomes appropriate, unless there's some additional rule, like Rule 651C, requiring automatic reversal. But there is no additional rule here, and petitioner has not what petitioner asks for, that this court just do so in this case without engaging in the normal rulemaking process, is an exceedingly rare outcome. Now, I would add that though this court's decision in the Pinconsley case doesn't mention a prejudice prong explicitly, its outcome and reasoning implies a similar understanding of how to approach claims of inadequate representation under of 214.01 counsel. There, the court assumed, without deciding that a reasonable assistance standard applied, it held that the alleged unreasonable performance, which was the failure to raise claims of putative legal errors, could not amount to unreasonable representation because such claims were not cognizable under Section 214.01 and therefore could not have succeeded. So that is a prejudice analysis without stating it explicitly. And the same outcome is proper here, whatever the standard of representation, because petitioner clearly was not prejudiced by his appointed counsel's failure to pursue a 214.01 claim that, like in the Pinconsley case, could not have succeeded. It was incurably time barred, it was procedurally barred, and it was meritless on matters of law. I would also add, with regard to petitioner's discussion of the Tedder case, that case does discuss a due diligence standard for discretionarily appointed counsel in the mandamus context, relating to a prisoner's grievances about the conditions of his confinement. But that's a 40-year-old case, and that has been very limited in its application. And subsequent cases, like the Maloney case, have suggested that
Mr. Elsner, your time.
Thank you, Your Honor. If there are no questions, I would ask that this court affirm the decision of the appellate court.
Thank you very much. Mr. Boyd, rebuttal. Unmute your, unmute. Okay, thank you.
My apologies. Thank you, Your Honor.
Thank you.
The first thing I should point out, the state makes much of the fact that Ronald's petition is not meritorious. And I would concede it is not. This case is not about Ronald's petition. This court never would have taken this case simply to pass judgment on Ronald's petition. This case is not about Ronald's petition. This case is about Section 214.01 petitioners as a whole. And the question, the fundamental question here that I think this court should be asking itself is, are the procedures or lack of procedures that were followed here in the circuit court's treatment of this petition acceptable? And the answer is obviously no. We had appointed counsel. We had no amended petition. We had a motion to dismiss that was filed by the state. We had no response to that. Then we had a hearing on the motion to dismiss in which counsel did not receive notice. Then we had the hearing itself in which neither counsel nor Ronald were present for. The state says, well, maybe this doesn't comport with best practices, but okay, it's really not all that big a deal. No, Your Honors, it isn't just that this doesn't comport with best practices. This was awful. This was just awful, regardless of the merits of Ronald's petition. What happened here down in the circuit court in Stark was terrible. And if this court puts the stamp of approval on that type of procedure, what is going to happen, what will inevitably happen at some point, is that some litigant who has a meritorious claim is going to be harmed. And that will happen because the circuit court, and I hate to use such frank language, but the circuit court blows this matter off like it did in Ronald's case. It takes us at OSAD between 12 to 18 months to get to this thing. It takes the people at the state appellate defender's office maybe another 6 or even 8 months to get to it. Then it takes the appellate court another year to render a decision. And so we've got somebody with a meritorious claim who sits for up to 3 years waiting for relief. And this happens because the circuit court didn't follow the proper procedures. And why does this happen? Well, maybe because this honorable court has decided to whitewash something like this with the brush of harmless errors. Your Honors, don't do that. Don't do that. We, and by we, I mean the defense bar, the prosecution, and the courts in the state of Illinois, we are better than that. We can be better than that. We should be better than that. And we are supposed to be better than that. Now, let me just make another point or two here.
May I ask you to,
Please.
You made a very strong argument here, certainly, sir, that certainly we are all very concerned about. But looking at the People versus Vincent case and the procedures there, it would appear the only difference between procedures followed in a case from this court and what happened here was in Vincent, the defendant, the petitioner, was not represented by counsel. And the court said it's within the trial court's authority to dismiss the petition just on its face. Here, ultimately, that's what happened, is the trial court dismissed the petition on its face. We have the other piece of it that the court went beyond and appointed counsel when it was not required. But at the end of the day, what the court did here appears to be very similar to what this court approved of in People versus Vincent. How is it different?
There's two differences. And the first is the court in this case didn't simply dismiss this petition after taking a sua sponte look at it. The court granted the state's motion to dismiss. The instant case is in a completely different procedural posture than than Vincent is. And Justice Kilbride acknowledged that in his dissent. He said, if the state had filed a motion to dismiss in that case, the petitioner would have had a chance to file a response. So what we've got here is a case that's not the same as Vincent for whatever reason. I don't know why the state prosecutor decided to do this, but he or she did. There was a motion to dismiss filed. And once that motion to dismiss was filed, this case was taken out of Vincent's purview. This case then squarely landed into the purview of, well, we have a motion to dismiss filed, and now due process requires, and just a fundamental notion of fairness requires that we give the petitioner a chance to respond to that. So
And
these
what
are,
should the trial court have done?
what should the trial court have done? It would have been a very simple matter. Once the trial court received this motion to dismiss by the state, it would have taken the trial court or the court's clerk all of about 30 seconds to draft a 2-line statement saying something like, defense counsel is granted 30 days or 60 days or whatever it might be to file a response to this motion. The state is granted an additional 14 days to file a reply to that motion if it's necessary. And we're going to set this matter for a hearing on such and such a date. And you send that motion to the defense and to the state, and then you hold that hearing when everybody's present. That would not have been any sort of burden on the Honorable Circuit Court. That would have been the easiest thing in the world to do. So the idea that it would have been a very hard thing to do, a very inefficient thing to do, to provide Ronald with due process here just isn't the case. It would have been a very simple matter for the court to have allowed Ronald to respond, noticed up the hearing, and then held the hearing where both parties were present. That is not a difficult thing to do, and it would not have taken very much time, Your Honor.
Counsel, if we agree with you, and it goes back, what's to prevent the trial court from vacating the appointment of counsel and just deciding it on the basis of the petition that's on file?
That's a fair question, Your Honor, and I'd have to concede that I hadn't considered that. And if something like that did happen, I would almost certainly get the case on appellate review, and I would have to do some more research to figure out exactly where we would stand on that. But I guess off the cuff, I would acknowledge that, yeah, that's something that could happen. But what I'm asking for here is that this case be remanded with directions for the appointment of new counsel. Now, this court obviously doesn't have to do that. Even if it does decide to remand at all, it's not required to follow my recommendation, but I would recommend that new counsel be appointed. But to answer Your Honor's question, it would seem to me that yes, the circuit court could possibly go ahead and simply dismiss this thing pursuant to Vincent's sua sponte, but that would open up a whole other can of procedural worms that I would then have to do a whole bunch of research on when this case bounced back into my office. But that's a good question and a fair one, Your Honor.
Thank you.
And let me just make one more quick point before my time expires. The state makes much out of the fact that, well, this record isn't sufficiently developed to evaluate counsel's performance. What the state seems to be arguing is that, well, we don't know what counsel did behind the scenes. Did counsel do something behind the scenes like talking to Ronald or examining the record? And we don't know. But that's not the problem in this case. The problem in this case is what's on the record, and it's apparent from the record. And it's that counsel didn't provide any actual representation for Ronald in the circuit court. That's undisputed. Justice Liston pointed that out in his dissent, and everybody acknowledges that. Counsel did nothing in the circuit court on behalf of Ronald. And the record is full of that. There just can't be any dispute about that. So this argument that, well, we don't know exactly what counsel did behind the scenes, that just doesn't matter. And Your Honor, let me just wrap up very quickly. What we're asking for here is not unreasonable. We're asking that Section 214.01 petitioners be allowed to respond to motions to dismiss that are filed by the state. We're asking that appointed counsel in Section 214.01 petitions are not allowed to do nothing. And for that reason, we ask this court to reverse the decision of the Third District Appellate Court and remand this case for further proceedings with new counsel. If there's no other questions, thank you very much for your time this morning, Your Honors.
Thank you, Mr. Boyd. Case number 124807, People versus the State of Illinois versus Ronald Lee Stoecker, known as case number 3 on the agenda, will be taken under advisement. Mr. Boyd and Mr. Elsner, thank you very much for your arguments this morning.